Hello, good afternoon, dear audience and followers from all over the world. I hope you and all your loved ones are well. My name is Martin Weda, and within the framework of the Chair of Culture for Peace and Human Rights at the Faculty of Social Science of the University of Buenos Aires. The conference, Feigning Threats versus no feigning warnings, a general solutions to problems of contractual coercion and constitutional condition blackmail will take place. At the 7th, we will have the opportunity to hear valuable contributions from two experts in the field. The conference will be broadcast on various digital platforms where the audience can listen and ask questions that will later be addressed to the speakers. First, we will have the participation of Dr. Einer R, the current Petrie Professor at Law at Harvard Law School and founding director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics. He served as chairman of the Antitrust Advisory Committee for Obama's campaign. He teaches a variety of courses ranging from antitrust, contracts, corporations, legislation, and healthcare law. Before joining Harvard, he was a law professor at the University of California, Berkeley, and clerked for Judge Norris and the Ninth Circuit and for Justice Brennan on the Supreme Court. He received his law degree and his doctorate of law from Harvard University, graduating first in his class from Harvard Law School. He is the author of numerous articles on variety of topics, even broader than those he teaches, including antitrust, public law, corporate law, patents, the legal professions, and health law policies. His most recent books include U.S. Antitrust Laws and Economics, Global Antitrust Law and Economics, the Fragmentation of U.S. Healthcare Causes and Solutions, Statutory Default Rules. Without a doubt, it is an enormous honor to have his valuable virtual presence to significantly enhance the cultural quality of our events as a wonderful gift for posterity. Likewise, we will have the participation of Luis David Fernandez, current professor and director of the Chair of Culture for Peace and Human Rights at the Faculty of Social Science of the University of Buenos Aires, the author of numerous books and articles related to legal theory, constitutional law, labor law, human rights, education law, and culture. He works alongside Adolfo Pérez Esquivel Nobel Peace Prize in the search for peaceful and democratic solution to the various political and educational challenges of the modern world. I would like to note that Professor Einer R will have 25 to 30 minutes to present his insightful contributions on the subject. Professor Elhauge, the floor is yours.
Thank you very much. Look forward to presenting. I'm having one technical difficulty, though. I can't share my screen because it says it's disabled for, oh, is it working now? Let's see.
Yes, Professor.
So can you see my slides now?
Yes, yes.
You can? Okay.
Mm-hmm.
All right. Okay. Still, all right. So my talk, thank you again for the kind introduction. My talk, as Martine said, was about contrived threats versus uncontrived warnings. And part of the motivation for this is to deal with two areas of law that, at least in the United States, have long been thought to be entire quagmires that are unsolvable. That is, what exactly constitutes contractual duress? What exactly constitutes an unconstitutional condition? In particular, the problem is that sometimes it is held to be the case that even when you threaten an action that is otherwise totally lawful, and that induces an agreement that would otherwise be lawful on its own, sometimes such threats are held to be legally coercive, but sometimes they're not helpful. And the question is, how do we tell the difference? Why is it one way rather than the other? So the standards have been understood to be incoherent. A lot of people have even written that it's just too hard to solve. And the Supreme Court itself in the United States has admitted they just can't articulate exactly where the line is. The unconstitutional conditions doctrine has itself rests on an underlying doctrine of contract law of duress, and it has its own conclusory standard. It says, well, such threats can lead to illegal coercion when the threat is, quote, improper. But what's an improper threat and what isn't an improper threat when the action is actually lawful has not really been very clearly defined. So my simple solution to the problem is to conclude that those sort of threats should be deemed improper only when they're contrived. And what I mean by contrived is the threatened action would not occur in a no-threat world. If you couldn't make the threat in order to induce the agreement, you would not otherwise engage in that threatened action. So you're threatening to do something you normally wouldn't do in order to induce the agreement. That's what makes it improper and potentially coercive. So for the cases I'm going to be talking about, I'm going to assume that the threatened action is lawful and that the agreement, that the uncoerced agreement on the same topic would be lawful as well. There are some cases, of course, where the threatened action is unlawful. And those cases are easy. Somebody puts a gun to your head and threatens to shoot you unless you sign a contract. Assaulting somebody with a threat to shoot them is itself illegal. But in those cases, whatever the standards are that make the actions or the agreements otherwise unlawful, settle the issue. The hard question is when we have lawful action and an otherwise lawful agreement. I am also going to assume that the recipient has the right not to be coerced on the topic. Sometimes threateners do have the power to coerce. For example, the government has the power to regulate often. And in those cases, it can be legal even if the threat is in fact coercive, since they have the power to coerce. And I think one of the reasons I separate this out is I think especially for unconstitutional conditions, these issues often get confused. And as a result, people are talking about unlawful threats. We're talking about cases where the recipient doesn't have a right not to be coerced. But I'm assuming these sort of situations in order to present this is the case that I think is the hardest and is solved by the contrived threat, uncontrived warning model. Now, again, I want to distinguish what I mean versus credible threats. So a contrived threat might sound similar to the distinction between credible threats and non-credible threats that has dominated a lot of economic analysis, but they're different. So to define a contrived threat, the baseline I'm looking at, what we call the but-for world baseline, is what would you do if no threat could be made? Whether a threat's credible, that turns on the post-threat baseline. That is, after the threat, would you carry it out or not? And those are different issues. Now, you might think, well, a contrived threat could never be credible because by definition, something you wouldn't do, but for the fact that you made the threat, thus you don't have the incentive to carry it out. But that's not the case. One reason is that threats can be staged day by day. And those can be, even if you wouldn't want to carry out the entire set of threats over all the different days, doing it day by day can be an expected benefit because the recipient's refusal to cave is less credible. And thus, if you do it for a couple of days, you're likely to get them to agree, and the profits or gains from doing so are enough to make it credible to start doing it for some days. Second reason is that carrying out a threat can give you reputational benefits for future threats. So if you make a threat, even if it's contrived, and you might want to carry it out even though you don't really benefit just from carrying out that threat, you can get benefits for future threats and thus get gains from that. I think also it's the case, at least for human beings, making the threat itself changes the emotional calculus. It can make people feel emotionally committed to carrying them out. And sometimes you can engage in various commitment devices. You can have a contrived commitment, or you can incur debts or costs in contract type cases in a way that changes what you're likely to do. And then finally, often whether it's credible is not an on-off issue, at least from the perceptions of the recipient. As long as they perceive some low probability that the threat might be credible, it can induce an agreement. So for example, if we go back to my classic example of somebody puts a gun to your head, threatens to shoot you unless you sign a contract, you could think, well, that's not a credible threat. Why would they carry it out? If they shoot you, they lose a bullet, and they now are threatened with criminal liability, and you're dead, so you're not able to agree to it. But if you're the recipient, even if there's a 1% chance that it's credible that they'll carry this out, that can be more than enough to induce agreement in face of such a threat. Next, I would point out that contrived threats can be harmful even in cases where they're not credible. One reason is the reason just mentioned. They might be perceived to be credible even though they're not in fact credible. But also even if it's misperceived not to be credible, it can lead to actions that harm both. They might in fact carry it out and be bad for both sides. And just the making of a contrived threat, if nothing else, it's going to lead to unnecessary conflict and negotiation costs. So you can deter the threat from being made in the first place, where the world would be better off both for future cases. So I think there's actually no need as a result to inquire into the credibility of the threat. We really want to focus on the contrived or uncontrived nature of it. All right, so we'll start with the general contract standards. So as I said, the test generally under contract law is, was it an improper threat, a wrongful threat? But these are cases where the action's lawful. So the question is, well, how do we know what's improper or not? And as I said, the standard generally is conclusory, but a few of the comments in a restatement offer suggestions about when the threat is likely to be found improper that I think fit the theory of whether it's contrived or not. One is whether it lacks any objective reason to engage in the conduct. If you don't have an objective reason to do it, it's more likely that it's a contrived threat that you wouldn't do in a no-threat world. Likewise, the last element under that first big bullet point, if there's no significant benefit to you from the threat and action, you wouldn't do it in the but-for world. And also questions whether it's already covered in the contract or not. If it's was already contracted in, is more contrived to threaten to not carry out the contract for the midstream negotiation cases. So the first element is this improper threat. The second element depends on the kind of contractual situation. In cases where there is no mutual consideration, it's enough in those cases that the costs to the recipient are greater than the modification, the value of modification to the recipient. If it's not a case of a midstream modification with no mutual consideration, you have to prove that there's no reasonable alternative. That is, you have to prove that the threatened action would leave the recipient significantly worse off. And in the cases where there's one-sided modification of contract, you don't have to do that, basically because we know they must be left worse off because contract remedies must not be sufficient to put them in the same position as enforcement would have been, given that they're willing to accept the one-sided modification. So a concrete case by now might be overdue. So there's the great case of Alaska Packers. Basically, a bunch of fishermen in San Francisco agree to a contract where they're going to be sent to Alaska to work in a fishery. The fishermen are sent there. The pay they agreed to take is $50. But when they get there, they basically say, well, we're not going to work unless you raise our pay from $50 to $100. This threat is contrived because taking the threatened action meant that they were giving up their pay. Now, one might wonder, well, but they could be sued in contract damages. But the court basically assumed that they were judgment-proof. So really the question that they had is, under the situation with the contract, we get $50. With the modification, we get $100. But if we carry out the threat, we would get $0 for the workers. So in this kind of world, if the fishermen couldn't make the threat to get that modification, they would just perform the contract because they're better off performing the contract than getting $0. Allowing those kind of threats, thus, would induce modifications that harm the victim ex post, the fishing company in this case, but also harms both of them ex ante, because if you are a fishing company and you can foresee that you can be held up in this way by a threat in midstream, you're less likely to invest in the fishery and sending the fishermen out there in the cannery and all the other investments they made. And those investments are part of what makes the labor and the fishermen. There's uncontrived variants, though, that one could imagine. Suppose the reason they threatened to walk off the job was instead that somebody else offered them a $90 pay. Well, in this case, the modification they're seeking, they'd get $100 pay. If they carry out the threat, though, they get $90. If they stick with the contract, they would only get $50. So if you call that threat coercive and ban the modification as a result, the problem is they won't make the threat to get the modification, but they will instead just walk off the job and work for the other firm. There's other parts of the Alaska Packers case that suggest that's not an improper threat. And the reason I think is, in that case, it's what I would call an uncontrived warning. It's simply warning what they're going to do and what they would do even if they couldn't get a modification, even if they couldn't make a threat, and allowing them to communicate that to the fishing company in those cases produces a mutually beneficial agreement. They're both better off with a modification than with the threat being carried out. And even though it's true that they're paying more money to the fishing company than they expected, the alternative would be even worse, because otherwise they must have thought it was worse because they accepted the modification over the threat being carried out. So actually, to allow this kind of agreement would reduce harm to their incentive to invest into the contract price. Wolf versus Marlton is a case where you can also make the contrived versus uncontrived warning. So in this case, a couple bought a house, or they contracted to buy a house, and their lawyer basically threatened that unless they got the security deposit back, they would carry out the purchase of the house, but resell it to somebody undesirable who would lower the value of the development and harm the developer. So in this situation, getting the deposit back is better for them, but if they didn't do that, they'd be better off reselling to the higher bidder rather than limiting their resale options to undesirable purchases. So in this case, if you deter the threat from being made by calling it duress, they wouldn't make the threat, they would instead resell to the highest. But what if we had an uncontrived version? What would that look like? Well, suppose what's going on instead is that child molesters have to pay above market rates because they usually have a law, at least here in the United States, where you have to publicly notice where the child molester is living. And the sellers, the divorcing couple in this case happens to know there's a child molester who pay an above market rate, and they simply inform the seller, well, if we have to go ahead with this and resell, that's where we're going to sell to because that makes us the most profits. So notice here, again, they're best off with the deposit back, but they're better off reselling to the child molester rather than reselling to buyers who would not reduce the development. So if you can't make the threat to get the deposit back in this case, they would resell to the child molester. That would be worse for the developer. So they're both better off instead allowing the communication of this fact that they're going to resell to a child molester and getting a mutually beneficial agreement to get the deposit back and avoid that. So basically, to generalize the situation, it's an uncontrived warning if the modification that's being induced by the threat is more valuable to the threat maker than the carrying out the threat, and that in threat is more valuable to them than the contract is. So in those cases, basically, if you cannot make a threat to induce a modification, if we basically X'd out the T in this, they will in fact take the threatened action, and both sides got to be worse off because if we prevent that threat, because we know that both sides thought the modification was better than the situation with the threat being carried out. On the other hand, it's a contrived threat generally if the value of the modification to the threat maker is greater than the value of the contract to them, but the value of the contract to them carrying out is more valuable than carrying out the threat. In those cases, if you can't make this threat to induce the modification, you won't get the threatened action. Prevent that. The recipient will clearly be better off because they value the situation with the contract over the modification. And the threatener even is better off in ante because preventing those kind of threats prevent modifications only if they reduce joint welfare. That would come out in the original contract. So there's other doctrinal elements, particularly no reasonable alternative that I mentioned. I think in the interest of time, these are more details that I'll skip over to focus on the main test is contrived versus uncontrived. The social should be distinguished. I think the closest prior work was by the famed philosopher Nozick. And I think the difference is mine is it's a purely predictive test, as you can answer the question whether it's contrived or uncontrived without making independent judgments, normative judgments about the action. And I think that's important to have a test like that because the action, after all, is lawful. So we don't really have a legal standard for carrying out the threat to be illegal. So the test is purely predictive. What would the threatener, in fact, do in a no-threat world? Nozick instead used what I call a mixed basis. It's whether it leaves the recipient significantly worse off than predicted or than morally expected. And the problem is that the latter is unclear, but also it means that it undesirably condemns with some uncontrived warning. So it may be that somebody threatens to do something that is morally dubious, but is legal, and they're actually going to do it. So it can, it might seem sensible to say we're going to call that sort of threat coercive, and we're going to make it illegal. But then what you actually have is the threatened immoral action would actually occur. So condemnation there is actually going to worsen things rather than make them better. There's a few other more technical distinctions, but that's, I think, main important. I think this sort of test can also explain the Medicaid defunding threats. So this is a major U.S. Supreme Court case that directly drew on contract law to assess a constitutional issue. So the threat was basically to the states to take away their pre-existing Medicaid funding unless the states accepted a Medicaid expansion. And this threat, I think, is contrived because there basically was no significant faction in Congress that preferred eliminating Medicaid to existing Medicaid. They just wanted the Medicaid expansion. So we have a situation where to Congress, the value of the situation with Medicaid expansion is greater than pre-existing Medicaid, but pre-existing Medicaid is greater than the situation with no Medicaid. And it basically, they said it's the threat to deny additional Medicaid funds unless the states accept Medicaid expansion is okay. That makes sense, I think, because that's an uncontrived threat. Congress would only be willing to do it to offer new funds to get the expansion. So that's the opposite situation as the first one, where they struck down the threat to take away pre-existing Medicaid funds. So I think we can say it's based upon whether one threat is contrived, one threat is uncontrived. That's our contract law sort of situation. We have a few more Supreme Court examples, but I think, again, since I'm running a little behind, I will skip over that one. And the King v. Burwell case, another healthcare law case, was basically interpreting Obamacare to deny federal tax credits to states that didn't create insurance exchanges. And I think that would have resulted in an unconstitutional threat, because that would have been a contrived. So let's go more to the general proof that I think for unconstitutional conditions. To be an uncontrived warning, I think it would have to be the case that the government prefers the condition benefits over having no benefits, but prefers no benefits over the unconditioned benefits. In that case, if you said to the government, well, you can't impose a condition, then they won't impose a condition, but they'll simply give no benefits, because the government views that as better than the unconditioned benefits. And thus the recipient's going to be worse off, because any individuals who accept a condition must think they're better off with conditioned benefits than no benefits. But sometimes I think it's a contrived threat. So the government might prefer conditioned benefits over unconditioned benefits, but prefer to give unconditioned benefits over not having any benefits at all. In those cases, if you say, well, you can't impose this condition, the government, in fact, will give unconditioned benefits, and all the persons, or in the federal state case, all states, will be better off whether or not they would have accepted the condition. And the government actually gets the preferred result for individuals who would have rejected the condition. They get their unpreferred result for individuals who would have accepted the condition, but having a constitutional autonomy right exercised according to governmental preferences rather than individual preferences would violate the positive underlying constitutional right. So I think this fits the constitutional case law on unconstitutional conditions, where there's been the same kind of ranking determines whether or not it's deemed an unconstitutional condition or not. So if we go through the pattern of cases, I think it fits the test quite nicely. Sometimes it gets phrased in terms of whether it's a penalty versus a subsidy. But obviously there's a difference. There's always either when is taking away a benefit a penalty versus not providing a subsidy. And basically, I think if you go through the pattern of cases, the ones where they call it a penalty is when the threat of conditions is really contrived. And what cases where they call it a subsidy is when it's really uncontrived. All right. Similar thing under property law for where they require a nexus. It also seems to be linked very closely to whether or not the threat is in fact contrived. All right. And then finally, I think it helps explain plea bargaining. So some people who just focus on the coercive impact on the individual kind of wonder, isn't all plea bargaining coercive, since you're threatening to put people in prison for long periods of time unless they agree to something? I think the answer is, despite the great coercive impact in terms of that may lack another reasonable alternative other than to agree, the threat to bring the charges is uncontrived. They're going to carry it out if they couldn't plea bargain. So people will be worse off without the plea bargain. On the other hand, when you make a contrived threat to bring excessive charges in order to encourage plea bargaining, that should be deemed unconstitutional. And again, I think that fits the pattern of the case law. All right. There's a bunch of other scholarly tests that I go through to distinguish, but let me move on a bit to make sure we finish on time. How much more time do I have, Martin?
Okay. Thank you very much.
Do I have much more time, or am I out of time already?
Yes, 5 minutes. No.
Okay. All right. So in the last sort of contract situation I want to talk about is threats that induce new private contracts. So we talked about threats to exercise rights to terminate a separate, if it's a threat to terminate a separate contract, that's contrived. On the other hand, there are cases like the Batsakis case, where there's a poor woman in war-torn Greece, and they basically said, we'll give you some drachma that, the dollar value was very small at the time, in exchange for her agreeing to give $2,000 when she got back to the States. That was upheld. And I think the reason it was upheld is even though she had extreme need for it, the threat was uncontrived in the sense that this was just the market price that there was for drachma at the time because people were starving in the streets. It was an extreme situation, but we're better off having more money come into the country, help people, even if they're charging a lot for it. Is a situation where people were selling off, gold heirlooms for small amounts of money because people were so desperate for cash. So if it's just at the market price, that's an uncontrived threat. On the other hand, there are cases where there's a threat to withhold desired goods from people who are cut off from the market. So clearly, when the seller themselves are the one who cuts them off from the market, that's deemed contrived. But there's also cases where there's an adventitious sense in which you're cut off from the market. So, if Bill Gates comes to the emergency room, the doctor says, well, I'm going to only treat you if you give me $1 billion. Well, that's a contrived threat because otherwise they would go ahead and treat them at the market price if they couldn't make the threat. Similarly, there's an old famous case of Post versus Jones, which had a similar kind of situation. Lastly, I want to talk about the interesting issue of blackmail. Because sometimes, when you threaten to reveal information unless you get money, sometimes that's deemed blackmail, but sometimes not. And I think that it goes again to whether it's contrived threat. So if there's no significant benefit to revealing the information to the blackmailer, that's a contrived threat. So contract law would always condemn it in that kind of situation. And you need some significant benefit, I think, because otherwise the cost of revealing information includes making persuasive enough to reduce risk from slander suits. On the other hand, when there's a significant benefit to revealing information, those should be deemed uncontrived warnings. It benefits the contracting party, but the problem is it deprives third parties of information. So if the information is about something like a crime, then the third party interest is high, and contract law always condemns those. But for other topics, the third party interest can vary, and contract law tends to leave that kind of local issue to the judges. So the blackmail statutes may, as a result, seem over-inclusive, that they include cases and condemn things that we wouldn't want to always condemn. But in practice, that's not really the case. So think about the normal kind of litigation settlement that occurs, at least in the United States. One party agrees to pay the other party a lot of money. In exchange, they say, well, you can't discuss the information that's in this lawsuit. You could think of that as a blackmail thing, going to continue this litigation unless I'm going to reveal sort of this information unless you pay me off. But the threat there, the implicit threat is quite contrived, which is they're going to continue the litigation. The information is not going to come out. All right, that concludes my presentation. Thank you very much.
Thank you very much for your presentation, Professor Einer. And Professor Luis David Fernandez Zambrano, you have floor. Please.
So trying to get back to, do you still see
Professor Luis, tu audio, Professor Luis, su audio. The floor is yours. Okay. No se te escucha, estimado.
Hello, hello, hello. Hola,
Okay.
¿qué tal? ¿Cómo están? ¿Qué tal? One moment, please. Hay un problema técnico, parece, con la cámara, o me logran visibilizar tranquilamente bien.
Se te ve correcto y se te escucha el audio. Adelante.
Okay. One moment, please. A ver. Yeah. Esteemed, hello. Esteemed Greg's virtual spectre is with great reverence than I find myself once again in your presence, particularly honor on the Wendy's geographic course along the eminent professor, the Elhauge, whose luminates in the legal firmament on the contractual law within the academic sphere of Harvard University is unparalleled. Moreover, it feels me one moment please, that's right. Parece que hay problemas con el audio. Oh, no, pues no lo logro ver. Okay, that's right. It filled me with immense joy to acknowledge the profound paternal bonds, the shards with the Argentine Republic's arms. More specific, with our esteemed University of Buenos Aires. In these very connections, that ignites the friends on the life within Mac spirit. That is the absolute imperative to delineate within the exposition the significance of elucidating certain trends and providing accompanying differentiation. The contractual coercion pertains on the circumstance wherein once the party to a contract complex the other party or the accepts the agreement to tracks or under pressure. Exists contracts to underscore that contractual coercions entails and violation on the affect party freedom of choice to renew the requisite consent for the validity of a contract, distinguishing contract coercion from other related consent, indispensable for precise juridical analysis. Intimidation, for instance, entails the use of threats, the behaviors that instills fear on to induce a person to perform an act the way with other ways refrain from. However, unlike coercions, intimidation may not necessarily be lied to a specific contract. Fraud, on the other hand, involves decision on the mere representation of relevant facts to induce someone to enter into contract. While there may be some overlap with contractual coercion, in terms in between a consensus, fraud focuses on the false or misleading informations, whereas coercions is more closely associated with the union pressure, union influential reference to leveraging an special relationship of trust and authority to gain advances is a contract. Though they made their resemblance to coercion in a certain aspect, undue influence the distinguished by the abuse of positions of power rather than direct acts of their physical or emotional coercions. It is imperative to discern between legitimate acts and those that are illegitimate or fictitious. Legitimate acts such as the natural consequences of the filing through other terms of a contract do not constitute the control coercion. However, illegitimate acts such as physical violence and the property destructions inviolated consents and may be considered as coercions. Identifying this demarcation and essential for determining the validity of a contract and safeguarding the rights of the parties involved. However, the contract coercions, within the current milieu, it is most the significance on delineate various forms of the contract coercion, spanning a broad spectrum for the physical tracks to emotional or social pressure. The physical tracks entail the actual or threatened use of the physical force, the agents and person on property or procure the consent in a contract. This may encompass direct intimidations, physical violence, on property destructions, economic tracks involved the utilization of financial power to swell an individual decision-making. This can manifest to withholding necessary financial recourse from the other party or promising economic gain in exchange for contract acceptance. Social coercion pertains to pressure exerted by social growth, such as the family, friends, or college, and compelling an individual to accept contract against their will. They may involve social ostracism for reputational loss if the individual adhere to contract terms. Emotional coercions and child manipulation, a person failing the social fears, kill, or love to obtain their consent in the contract. This can manifest through threats of the abandonment, emotional manipulation, or emotional blackmail. These forms, the coercion, may prove for the utility to identify, the compare to overthrow, to pressure like the physical violence, emotional and social coercion is particular made the so-called and the subjective, the rendering them more challenging to substantiate win a legal framework. Nonetheless, it is imperative to acknowledge and address this form of coercion to assure integrity and the fairness in contracts. Let recall some emblematic cases. Historical, the case of the William versus Baker Thomas Fortignori cause, the 1,816 5 years in United States. You underscore the importance on the examining equity in contracts. In this exam, the Supreme Court found that the tidy retention clause in the consumer goods, the sale contracts was unjust and thus invalidated the contract due to unequal power between the parties involved. In a more contemporary case, the UDL laboratories in Macon Diamond, the court deemed the inclusion of an exclusivity clause in the pharmaceutical supply contract as the coercion, seeing the weaker party and the essential conflict to accept the unfavorable trend to continue the business operations. These examples highlight to how the court the other cases, the contract coercions, recognize that tracks can be over when William Walker, Thomas Fortignori, and Morton Subball laboratories in Macon Diamond is both intensive. The course emphasizes the importance on balancing power between parties and the safeguarding the genuine will in the contract formation. Within that context, it is worth clarifying that score applies the several fundamental legal principles when evaluating contract coercions. The principle of lacks on the humane consent. First, the contract must be entered into the free and voluntary consent in the both parties. The coercion validates this consent by forcing one the party of the action. The terms they're good to not there while agreed now. Two, the principle of the substantial injustice. Court examine whether There is significant power disparity between the parties, resulting in the unfair or unequal trends. They may include the exploitation to the need of the vulnerability of the weaker party by the stronger one. 3. The principle of good, the fair, and equality violation. The contract must enter in the good, fair, and equality. Coercion violating the principle by the taking above of the party, the disadvantage of the by inducing to aspect trend contrary of their legitimate interest. By applying this principle, courts can determine whether coercion has correct and the consequently invalidated the affect the contract to protect the rights of the parties involved. For other part, in the like on the occurrence, there may exist a collective consideration and the potential solutions. Forbidding the contract coercion. There are several legal remedies available and made, and restoring equity and the safeguarding their rights. 1. The contract coercion. Contract coercion is common measure when it is demonstrated that one of the parties was coerced into entering the agreement. This entails the determination of the contract and the restoration of the party of the position prior of the executions. 2. Damage. In addition, the contract rescissions. Victims of the coercion may be entitled to matters and compensate on losses suffered and the result of the coercions. The damage may encompass direct financial losses as well as emotional or reputational harm. 3. The contract nullification. Of extreme cases of severe legal coercions, courts may declare the contract null or void, rendering on the agreement legally ineffective from on the outset. They may be in the appropriate court the action when coercion has been particularly diametrally on the violates fundamental principle of the equality and justice. That's right. Regarding ethical consideration, the contract coercion poses a significant ethical implication in the legal spheres. First, it will most recognize that coercion undermines the autonomy and the freedom of the contracted parties, other contain fundamental principle of the justice and equity in the contract formation. Coercion can lead to agreement that are the moral, questionable, and do not truly reflect the will of the involved parties. From an ethical perspective, the role of the lawyer, the legal professional, the paramount in the safeguarding the rights and the dignity of the contracting the parties. Lawyers have an ethical responsibility to represent them, the interests of their clients fairly and ethically, which includes ensuring that contract and the enter on the voluntary and the without the coercion. Lawyers must be mindful of the potential signs, the coercion in the contract information, and act all integrating to address the end situation where once the party is suspected of the being coerced. This may involve advancing their claim on the importance of respecting the autonomy of the joint will of the other party, as well as the seeking equitable for the solution in the case of coercion and this has occurred. This principle of the importance on still on the private sector-driven training driven by both the state and the private sector play and the crucial role in promoting ethical practice in contract formation and the preventing contract coercions. The state is in the responsibility to establish and enforce laws and regulation to protect and the rights contracting the parties and prohibit coercive practice. This may include enacting laws that establishes clear the standards for contracts, validity, and the sanction for those engaging in the coercive conduct. On the other hand, the private sector has an important role to play in the promote the ethics and integrity in the commercial transactions. Companies and organizations can offer training and professional development programs that educate their employees about the importance of respecting the rights and the dignity contracting the parties and foster fair and transparent business practice. Collectivity states and private sector driven training can help create a business culture where contractual coercion is rejected and contracts based in the free will and the mutual respect and promote. This not only protects in the rights the contract, the parties but also strengthens the integrity and the trust in the legal and commercial system as a whole. The legal foundation to addressing the issue in the anti-conditional condition imposed by the government. The crucial on within the establishing the fundamental constitutional principle that guide the evaluations. This includes a delayed review of relevant amendments and constitutional doctrine. First amendment. The First Amendment guarantees fundamental rights such as the freedom of speech, the freedom of religion, the freedom of the press, and the right to peaceful protest. And conditions imposed by the government that adult restrict these rights must undergo rigorous scrutiny. Fourth Amendment, the Fourth Amendment protects against a reasonable research and seizures, requiring government authorities to obtain and to violate the judicial grants basis of protocols caused before carrying out these such actions, conditions imposed by the government that violate the constitutional protection may be deemed anti-constitutional. The doctrine proportionality, in addition to specific amendments, the concept of the proportionality is paramount the essence of the constitutional of the government imposes the conditions. This involves considering whether the government measure the suitable, necessary, and proportionate to achieve a legitimate objectivity. Evaluation parameters. Developing the framework for evaluation on the condition imposed by the government in the unconstitutional requires the consideration on several parameters. The importance of the public interest. The importance of the public interest sought to be protected by the government. The government. One moment, please. Okay, hay un problema con la batería. One moment.
Okay, Luis. 5 minutes.
That's right. One moment. It's very important for the construction about the solution to date. Important the public interest. That's important the public interest so to be protected by the government through the imposition of the condition must be evaluated. Is the public interest in the significance? It may justice a certain restriction, but it must be proportionate to pursue the objective. The necessary government measure is crucial to determine whether the government measure is truly necessary to protect the public interest at hand. The less restrictive alternatives on the available, the imposition of the more intrusive the condition may and deemed unconstitutional. The restriction imposed by the government must be proportional to pursue objective. This entails ensuring that the measure not the overly intrusive or restrictive in relation to the public interest in the security protect. Establishing a clear decoring the framework The framework to evaluating the constitutional government imposed on the condition and fundamental in the sure respect to individual rights and the enshrined in the Constitution, and the power balance between the exercise to state power on the protection of civil liberties. The blackmail and the legal and ethical analysis. Blackmail in the practice involves in training the close amount information and carry out amount action. The only certain demands are met. In the legal and ethical regards, the crucial and established on the clear distinction between the illegitimate tracks, the which constitute the blackmail and legitimate warning that inform about the consequences of based on the future action. The distinction between the tracks and the warning. One of the facts and considerations. In the analysis, blackmail distinguishing between the illegitimate tracks and illegitimate warning. Illegitimate tracks and the those and involving coercion and seek on the obtain some time in the exchange for avoiding the harm and the closing damaging information. In contrast, illegitimate warning and the communication that inform about the natural and forcible consequence on the certain actions without involving coercion and the acting on to gain on the informed bank. For example, in the individual informed, another about the legal concession of their past actions. Such thus the closing fraudulent financial information to relevant authorities. The communication is considered legitimate warning. The conversing someone detracts the extremely sensitive personal information. The honest there and the paying the sum of the money is action work the constitutional blackmail. The criteria of the legality to the material demands on the illegitimate to constitute the blackmail. It is crucial to establish the killer criteria. Some of the criteria demanding the coercion. As sensing under demand involves coercion, the tracks the harm to gain the unfair attack. The analysis whether in the ten behind the demands, the outing, the unfair, the abang, and the exploiting to vulnerability or the fear of the target individual. The potential harms. The potential harm that would be result from for the rationality today in discuss. And that's right. Now the effective the others blackmail is necessary to implement the appropriate legal solution. The missing declaration reform declared define the making and establishing proportional sanctions for those who practice it. Additionally, it's crucial to provide the killer guidelines for the enforcement, assuring to consistent and the fair response to cases of the blackmail. In addition to legal solutions, it's important to raise the public awareness about the blackmail and the ethical and legal implications. This can help the prevent the occurrence by empowering people to recognize and restrict blackmail, as well in informing relevant authorities when necessary. The conclusion the blackmail is practically poses both legal and ethical challenges by establishing and the clear distinctions between the legitimate tracks and the legitimate warnings, defining criteria for legality, and applying the appropriate legal solutions. Is it possible to effectively address this issue and the protect rights and the dignity of the developer, and his the more conversational and human versions? In examples, imagine the Harvard University in the United States, and the University of Buenos Aires in Argentina to join the forces to utter in the issue the blackmail in the academic setting. They decide to create the legal and ethical counseling the center to assist students and employees the facing the blackmail situation. The center offers free and the confidential help, the providing emotional support and the legal guidance to those in need. The center lawyers and available to talk to people over to phone and via email, providing and selling the APIs where the kind express the concern and the receipt device on how to hit on the will blackmail. The amazing thing about the collaboration is that both universities share resources and knowledge to offer the best possible help. They work together, they coordinate their efforts, and they ensure that no victims they will along the difficult situations. More time the university community begins to feel safer and more protected, aware about the blackmail increases, and more people feel comfortable responding these cases. The center becomes a role model and their university, inspiring positive change the tracks the academic world. In summary, the collaboration between the Harvard University and the University of Buenos Aires show how together we can address blackmail and create the safer and more ethical university environment for everyone. Finally, I want to thank one Argentine renowned professor and colleague from Harvard University, Dr. Einer R, for his willingness to take on the cultural commitment so that the wisdom continues to circulate and illuminate the past in the humanity in these territories. And above all, allows us to lay the foundation for solving the problems, the relevant or reality. Thank you very much and congratulations. Finish.
Thank you very much, Professor